Okay, this is Danny Hammond with the Foreclosure Solutions Group, and I promise to try to go in a straight line and say this is how we would put together your solution, the resolution to your problem with your foreclosure, and that's it's going to um, mean winning a lawsuit, and that's a hard thing to think about. And in Missouri, a lawsuit called a petition, and it seems like most states, um, I've worked in like, I think 23 or something like that, and it's called a complaint a lot. Um, and also, a federal lawsuit is called a complaint. And so there's really no relief in trying to remember it there. You're going to hear the word trustees, and they're going to have several meanings, which is extremely confusing to anybody, uh, even kind of me. Uh, so we'll say real quickly here, um, kind of what's the setup? What's the deal? And it's actually different in non-judicial foreclosure cases, the way we have to approach it, and it's really different. Um, that's a judicial foreclosure is like normal. It's how you would think about it. Um, the foreclosing party, and I don't say plaintiff and defendant very much, and this is the reason because in a in a judicial foreclosure, that's as it was imagined by the framers. Um, it's they think that you haven't paid them, and so they demand payment. You don't pay it, then they have to then do a foreclosure lawsuit specifically for that purpose. That's how it worked all the way from 1787 to 1999. And we talk about 1999 in part one of this. That's the repeal of Glass-Steagall, which was the regulation for Wall Street. So Wall Street has been unregulated um, since that time, 1999, and that is the problem. Now the problem is that I didn't put the microphone where it's supposed to be. That's the problem. So when I watch this and listen to it, there might be Danny do it over again at midnight 30. I was going to do it a lot earlier, but I sat down in a recliner for a minute and woke up about 10:30. So um, I think I'm wearing myself out. Okay, so the things that I want to say there is that so if you're in a judicial state and you've been notified, maybe by someone who has something to do with your loan, maybe um, those maybes are the changes from 1999. Um, anyway, so you'll be sued and you'll be noticed to be sued and you'll be the defendant if you're in the not in the judicial foreclosure state. So what has to happen, and the first thing that I'll look for is I want to find that lawsuit and read it because somewhere the foreclosing party or the plaintiff has to assert that they have been injured. They have an injury. There cannot be a case against you. You can't be taken to court uh, by someone just because they're filing and they are saying that you owe them money and they want to collect it. There's no such thing as the right to foreclose, by the way. Yes, there's a few cases that have said, oh, yeah, it's constitutional. Um, there's no right to foreclose. There's a right to collect money that's you loan to someone and they promise to pay it back in writing and it's signed. And that's the problem these guys have now is that they, for 20 years, they have hidden the note intentionally. And we'll get into that as we go along. But that's why you may have a copy of a note in your um, package. You got a closing. Um, and a lot of times, what they do is they'll pull that and you don't even have a copy of the note you signed. And I've talked to several people, and I've had people over the years um, that had the copy of the note with their signatures, but when they went um, it's when they went to see the copy or whatever somebody showed them, which is pretty rare now. It used to be that you could demand to go see it because they had said, "Oh, it's at our lawyer's office. It's in a safe that's in the floor." That's one that really happened. We went to look at it. It's an obvious copy. I've never seen an original promissory note. I've never seen one presented, and I have never seen them say they had suffered an injury. But that's not enough. To claim an injury, that's just a claim. That's not proof. And the founders, the guys that wrote the Constitution, they didn't want a litigious society. They wanted uh, They wanted someone to go to court and try to sue someone. They wanted them to have proof of some kind that they had a real beef, that they have a real problem with somebody that owes them money and they can't collect it. Uh, so to say you've been injured because you gave someone money, they promised to pay it back and they haven't done it, isn't enough. So it can't be an injury that they say we have suffered an injury. That's a claim. And that'd be like if someone that worked for you called and said, "Hey, I can't come into work today. I broke my leg." And if you heard this in another video, it's because I just use it all the time. And so the only way that you can know for sure is you have to drive to his house to look at his broken leg. And when you get there, there's a cast on it. So still, you don't have the kind of proof we're talking about. And that proof is called they have to have concrete and particularized evidence. The only way for you to do that is you now have to take them to somewhere, get the leg x-rayed, and see the broken bone. That is concrete and particularized evidence, which the burden of that proof is on them, the ones that want to sue. And now I'm going too far with my metaphor. Is that in this lawsuit in a judicial state, they have to claim an injury in fact. And in fact means that they have the evidence in that lawsuit because we're looking for standing. You have to have standing to take someone to court. If you don't have standing, the court has no subject matter jurisdiction. And I've been throwing these words around, and we're going to do it now so that we go in a line. So the first thing that you want to do is read that lawsuit, complaint, petition um, that that says they need to foreclose on you because you didn't pay them the money, even though you took the money and you promised that you give it back in writing. Okay, so if they haven't said that, period, if they haven't said it, there can be no standing, and that's the first part. Even if they said that far, we suffered an injury in fact, and we're including the concrete and particularized evidence in our lawsuit here, and you know we've proven that we are injured because we did loan money and we didn't get it back. And they have to use that same level and burden of proof to prove that it can, that the injury, the causation of the injury, can be fairly traced to you, the defendant. You caused the injury and they really have an injury. That's all got to be there or there is no standing. If they file the lawsuit without those words, then standing cannot exist, beginning at the moment that they filed it. And standing that's found to be deficient cannot be repaired. In other words, you got one chance, and they better have the proof. What's backwards is we all tried to prove to a judge that we thought didn't understand that we were being framed, that it was a fraudulent foreclosure. And so we tried real hard to find the statutes that would, or the laws, or the reason that the judge didn't get, and we don't understand why he doesn't get it, but we need to prove to him. And so we've all done that. And if you get a lawyer to help you, an attorney, he's not going to help you. um, and if you're watching this, you already know that. I have lots of people that paid 2,000 a month for 3 years to an attorney that they then lost. And we'll get into the attorney, but that's how you got to me. That's how you got to need me, because you couldn't find an attorney that would try to help you keep your house. Um, and and your real burden, you had no burden to do that. They have the burden. By they, I mean the foreclosing party. It used to be the lender. Okay, the foreclosing party was always the lender, um, or someone who purchased the promissory note, um, and either had it or proved that they had it when it was lost. And either way, they have to prove that the note is real, that the endorsements are correct, and all of the endorsements that are necessary there, and that the notes have been made on it, notes, written notes, that of the times that you paid and the times that you didn't, and how much you owed and when. Um, that is the burden of the plaintiff, foreclosing party, lender, or fake thing. Okay, the judge has the biggest burden that weighs on you, because the judge has to read what they wrote, and he has to see those words. And I mean, he has to see exactly those words, and it can't deviate very much. Can they prove they have an injury and it's real? And can they prove that you did it to them? And can they use evidence that does prove that? Okay, that's their burden. And the judge's burden is to read what they wrote and determine if they've said those words. And this comes from the doctrine of cases and controversies in the Constitution, and which those are the requirements for standing. The constitutional irreducible minimum requirements of standing is kind of what I just said. You know, the heading is longer than my explanation. But the judge has to look at it, determine if there is standing, and then write his reasoning, what he read, and how it's enough. And so there is standing, or it's not enough, and there is no standing. He then has to um, file this determination into the docket, into the case. Um, he's explained that there is standing, and that's because it's written here at this part of the lawsuit, complaint, petition, whatever. And I've never seen any of this all happen, ever. They will not mention standing. They will not defend it. They will not say they have an injury. And if you keep trying to get them to say that, and the judge doesn't review for standing, then you're going to have to sue somebody, because otherwise they're going to take your house. If the judge doesn't enforce that, he's not going to enforce all the statutes you're looking for. And by the way, all the laws are really good until 1999. They were good, and they still are, and they're there. They're not being enforced, and by a large, large number of judges that I can't even comprehend. But I can tell you that I've every county, every state, you know, the same exact tactic, same exact scheme. You're not special. We're all kind of alike. Sometimes they're longer and have more pieces, and sometimes they're not. But to me, they all look the same, and we fight them all the same way. So in a judicial case, you're going to have to sue someone, and the person that's committed the biggest problem, and they're the only one that you can find because everybody else is fake, is the judge. You're going to sue the judge, and I'm leading up to that, but not right now, because I've only taken care of 26 states, no, 24 states. Now it's completely different and the same at the same time, but harder to understand. If you're in a non-judicial foreclosure state, there, and this is what I believe, there's been a lot of people foreclosed that didn't know this was their responsibility. Oh, by the way, back at judicial, your only burden, the only thing you had to do was to say, I am not in default with any of these guys. With anybody in the lawsuit, anyone mentioned, you have to say that you're not in default, not in default with the foreclosing party on, and you're not. And they, they're going to, you know, scream and kick up dust and whatever, and you just got to keep from saying anything else, because if you say, well, my note was, I got a forensic audit, okay, and it says that my promissory note isn't where these guys say it was, okay, what you've done is you just admitted that you believe there's a promissory note at all and you went looking for it. That's kind of like somebody finding you in the creek where you threw the gun after the murder, and you pull out the gun just as the police come up, and there's your fingerprints on it. You don't go look for things inside of a lawsuit or a court case. You don't look for things inside of it that happened, because when I'm done here, there is no case. It's void. If they haven't said those words, there is no case. And so you're only arguing, did the judge look at it, and did he see that they didn't say those words, but he let the case go forward anyway? It's over at that point. It's over. The judge did it. And it's the worst thing he can do, because it's the only crime he can commit where the parties can sue him for damages. And that's what we're working towards. Now, if you're in a non-judicial foreclosure state, everything I said is true, but it's different to do. During the Great Depression, bankers had so many foreclosures, they wanted to do them faster, of course. And they talked the government, of course, into giving them the right to take the house and foreclose on it at night in the dark, somewhere around a courthouse, hopefully in the same county. By the way, I've had it where they said the sale was in the county where the uh, house was, but they really went to the next county over and didn't do it. And if you didn't go to your foreclosure, I understand why. It's hard. It's terrifying. But the thing is that if you go, you'll see no money changes hands. I've got a case right now where U.S. Bank Trust Company, which are in a large number of cases, they always come in late, and I don't, it's you can't find out if it's the U.S. Bank that's on every corner, or if it's somebody just using the name. I think U.S. Bank is involved, but it's hard to trace, and it doesn't really matter because they can't do all the same things that nobody else can do, because they really didn't ever own your note. No, the named lender on your promissory note and on your security instrument, which is a mortgage in the judicial states that I just mentioned, um, or the deed of trust in the non-judicial foreclosure states. Uh, it 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 doesn't have the name of where the money really came from, because it came from Wall Street to set up the mortgage-backed securities, and we aren't going to go over all that now because this is already too long, and I've decided that people like shorter ones. So let's real quickly do the non-judicial foreclosure problem, and that is that they can foreclose on you without going to court or telling the judge or telling anybody. They just do it, and they can. But that doesn't mean it's over at all. You have the right to sue them, and this is wrong, and you're the plaintiff, and you're naming the foreclosing party, and your lawsuit is about the fact that they're foreclosing on you without standing, and they must prove that they have standing. So you're suing as a plaintiff to make the guys that are foreclosing without going to court, you have to sue them to make them say why they have the right to do it, and you're saying they don't have that right and they can't say it. Now, so you're going to look for those words not in the original lawsuit because you're doing that, but they have to answer that lawsuit now. And it's in the answer that they must say, we have suffered an injury in fact, and we have included the concrete and particularized evidence, and we've also proven with that same level burden of evidence that the causation is the plaintiff. So you're really the defendant in the foreclosure, and this case is to prove that they're not really the foreclosing party because they don't have the proof to do it. It's really the same argument, and the words are the same, but in the judicial foreclosure case, it's in the original filing of their lawsuit, which is a foreclosure lawsuit. In the non-judicial foreclosure, you have to sue them, and that causes them to have to answer. And I believe there's been so many borrowers that didn't know they had to file a lawsuit, and they were fighting it, you know, in another way. But you have to file the lawsuit, and then you know you proceed to spark them to either give an answer, or if they don't give an answer, but they can't give you an answer that proves that they're really have the right to collect money from you, because there is no right to foreclosure. That is a collection action. Um, and and when they can't, then that's how you win. So it's an extra stupid step, and it is not constitutional, although the Supreme Courts of each state, 24 states, that do non-judicial foreclosure, has said that it can. And I've got to end this, because then if I don't, it will be long, and I'll never know if you like short ones better, because I'm kind of looking at that, how long people read. So next time, and remember that we're trying to raise money just to get a staff, because I've got to go back to my regular job. I've spent 2 years, and I'm down to zero money. There's no real money in this, but I don't mind doing it. But I need to have a staff to help me, because there's there's a spike in foreclosures right now, and it's as big as 2012, the best I can tell. I mean, no one, somebody could figure it. No, no one can figure it out. Um, and the spike is, I'm getting more calls than I had in the 2010, 2000 to 2013 range. Um, and it's all the same things. It's not as well done on their part. It's not as well done. And this is a good time for us to work on it, because the Supreme Court has disappointed us, and all the federal judges are afraid they're next, and all the state judges are just easier to beat. So, um, we're going to go more in how we do the case. We did how it started now, and um, I'm going to say goodbye. I think I hear my mom calling. It's getting dark, and the street lights are on. Got to go.